It gives me great pleasure to introduce Lawrence Liang before this most important audience. Lawrence Liang is basically a graduate of the National Law School, and he subsequently went on to pursue his master's degree at the Law and Development at Warwick. His key interests are law, technology, and culture, the politics of copyright. And he has worked very closely with Sarai, New Delhi, on a joint research project on intellectual property and the knowledge of the commons. Lawrence Liang is a keen follower of the open source, translating the open source ideas into the cultural domain. He's written extensively on these issues and is the author of The Public is Watching: Sex, Laws and Videotape, a guide to open content licenses. He has taught at a number of institutions, which includes the various national law schools, the Asian College of Journalism, Nalsar, and many other places. And very importantly, in addition to these teaching assignments, he is a part of us because he has submitted a PhD on the idea of cinematic justice at Jawaharlal Nehru University. And given that he is one of the most important voices in the field of law and sciences, he has a special place for us at the Center for the Study of Law and Governance, where all of us have had a very, very intimate relationship with him. And it is my pleasure to present you this accomplished scholar and a good friend to speak.
Thank you.
Thank you.
Thank you so much. I think my job has been done because I was going to talk about freedom of speech and expression, dissent, and sedition. So it was great. I hope we really win this one. So, thanks for having me here. It's always fantastic to be at JNU, but particularly so in the last 2 weeks, where in a way the entire nation is watching you, but not in the way that some people make that declaration. साथियों, इनिशियली मेरा प्लान था कि मैं हिंदी में बात करूंगा, but दो प्रॉब्लम्स है. एक तो ये कि there are some technical elements of what I'm going to talk about, and the second is my Hindi is so notional that आज के माहौल में I'm very worried that I'll be declared an anti-notional just because of my Hindi. So I will stick to the safe ground and speak in English. I'm going to talk today about the relationship between the right to dissent, freedom of speech and expression, and sedition. The key issues that have been, in a way, at the heart of the debate over the last 2 weeks. But I want to begin with an image that a number of you will be familiar with. This is an image that a number of you would have seen of kings and of leaders who love to have sculptures of themselves on top of a horse, right? I mean, holding a sword or marching up, but on top of a horse. But very often, if you notice, a lot of the kings seem like they're very nervous that they're going to fall off, right? There's this kind of precarious edge with which they're sitting on this horse. And there is a good reason for that. Because if the horse has always been the companion of power and the companion, in a way, of imperial ambition, the horse is also, however, extremely susceptible to one small, tiny, irritating insect, a little fly called the gadfly. The gadfly has this habit of getting into the ears of the horse and really kind of disorienting the horse making it move, up, and very often dislodging the arrogant sovereign sitting on top of the horse. And I'd really like to think about the idea of the gadfly in a way as the form of speech that is unacceptable to the sovereign. The sovereign's ears are closed to what the gadfly has to say, and yet the smallest of whispers threatens this arrogant sovereign. Because sedition doesn't always scream out loud. Sedition sometimes speaks in whispers. And I like this idea of the gadfly because the gadfly lends its name, in a way, to a certain ethos of dissent. So if you take, for example, Plato's Apology, which is about Socrates' death, he describes Socrates as a gadfly that speaks to the slow, dim-witted horse called the state. And Socrates himself says, I am the gadfly who you can easily swat, but if you kill me, you do it at a very high cost to yourself. So I would like to think of this idea of the gadfly as the first instance of a certain idea of political dissent and inaugurating, if you like, a gadfly jurisprudence. And this gadfly jurisprudence is what we need to return to today. Because the last thing that Socrates said before he died is, I'm the gadfly that attaches itself to the state, arousing, persuading, annoying, and constantly reproaching you. I advise you to spare me. We know that didn't happen, and his life was taken. But that was not the first instance in which political dissent was trampled upon. If you look at the history of gadflies, centuries later you have another gadfly in the anti-colonial movement, a gentleman called Mahatma Gandhi, who was charged, of course, under Section 124A for sedition. And in a remarkable trial, Gandhi said that affection cannot be manufactured or regulated by the law. One should be free to give full expression to their disaffection unless it incites violence. What is really remarkable is that Gandhi's interpretation of 124A has really become in some ways what the Supreme Court over the last 60 years has laid down the interpretation to be. And I'll come to this. But what is quite incredible about the trial was the judge in the trial, Justice Broomfield, was so embarrassed that he had to sentence Gandhi because he thought that he didn't deserve to be charged with sedition, that he apologized. And Gandhi said, unfortunately, you have only two options. You can either resign from your job or give me the harshest punishment. And at the end of the trial, Gandhi says that he thanks him for the courtesy that was afforded to him. If there was an example of grace, civility, and style in a criminal court, this is probably one of the best examples of this. Something that the Patiala, house lawyers clearly fail to see, even though they see the image of Gandhi every day as they enter the portals of law. But this idea of Gandhi or Socrates being charged with being traitors, what was remarkable was that Socrates himself never saw himself as a traitor. He instead spoke the language of love. And he said that I am dissenting out of love. Now, it's not a coincidence that we're talking about love, because Section 124A is a provision that, amongst other things, talks about the excitement of disaffection towards the state. Disaffection. It is, in a way, an emotive category. It's a category, it's about love. But when we therefore talk about the idea of what it means to be seditious, let's take it away from the language that has been given to us of national, anti-national, of traitor, betrayer, etc., and argue instead another kind of politics that reclaims what we may mean to think about a different form of love. Because if you were to look at the idea of what it may mean to think about a commitment to a principle rather than a commitment to power or a commitment to the state, then you have a situation in which one can articulate a politics of radical citizenship, which does not secede the ground in any easy manner for who has the right to determine who is a national or an anti-national. The problem with the entire polarized debate about nationalism is that it creates, in a way, an idealization where there is a kind of a wounded narcissism whenever there is any criticism, internal or external, of the state. And this extreme polarization borrows itself from the language of the friend and the enemy. And this is something that we need to absolutely reject wholeheartedly. This is a polarization which is fake. It does not allow us to talk about the real issues. And one way of doing that, if you read Professor Upendra Bakshi's article in yesterday's Indian Express, he makes a distinction between what he describes as a constitutional patriotism versus a statist patriotism. So a dissenter, to my mind, is someone who articulates this politics of citizenship, where you're looking in a way at articulating what it might mean to be committed to a set of principles, equality, justice, dignity, etc., rather than to the trappings of the formal state. And that's the reason why, any criticism that's grounded on a substantive politics is negated by this idea of the symbolic politics of nationalism. But the dissenter, at least in the Indian context, has always found a safe home. And the safe home, to my mind, is one way of thinking about Article 19(1)(a) or the freedom of speech and expression provision. If you look at the history of case law in India, there are many kind of normative justifications for free speech. Some of them are about the intrinsic value of free speech, what some would describe as the autonomy argument, while others are about the instrumental value of free speech. And there are different kind of instrumental values. You could argue, for example, about the marketplace of ideas. You could argue about the watchdog function of free speech in maintaining truth. But the most important ideal that has been consistently upheld to justify why one needs to have a very, very, very broad standard for free speech in India has always been the democracy argument. That free speech guarantees democratic rights and democratic institutions. So if you look, for example, at a case called LIC versus Manubhai Shah, the court says, freedom of speech and expression is the lifeline of any democracy, and stifling, suffocating, or gagging this would sound a death knell to democracy and usher in autocracy or dictatorship. So one way of thinking about the relationship between free speech and politics is to think of this as what allows or gives you a certain breathing room. It provides a safe space for you in a way to exercise any kind of political opinion that you want. And there are no safer spaces till now than universities in this country as the safeguards for this right to dissent. And on that count, JNU, if universities are a mirror of the health of a democracy, JNU presents an extremely healthy picture in which a diversity of opinion, a healthy regard for disagreement, and a tradition of dissent has been the marking features of JNU. And it's for this reason, I think that we need to ensure that JNU fights for the freedom of speech and expression, not only of the university, but for everyone else in this country. Now, what is substantively this idea of freedom of speech and expression? What does it actually entail? Because we always invoke the term, but I think it's important to nuance it to understand that freedom of speech and expression only makes sense if you think about freedom before, freedom during, and freedom after speech. The problem that we have in the contemporary era is that this idea of freedom has been hijacked. It's been hijacked by two primary trends. It has been hijacked on the one hand by the heckler or the stone thrower, right? So there is no freedom if there is always a fear of someone attacking you, someone violently, usurping your ability to speak through an act of violence. It has also been hijacked by the paparazzi. If the press played a crucial role in developing the history of freedom of speech and expression, it is unfortunate that these freedoms have been severely compromised by news channels of today. So how are we to bridge this gap, this huge gap that now exists between our commitments to free speech principles on the one hand and our actual free speech practices, in which you see that the greatest violators of freedom of speech and expression today are actually the press? How are we to make sense of the gap that exists, for example, between the good Supreme Court judgments that we have, the jurisprudence of free speech that we have, versus the daily reality where Kanhaiya Kumar can be picked up overnight on charges of sedition even though there is nothing that he said which is seditious. What do we make of this big gap? Are these principles therefore useless and exist only in the domain of some utopian politics? Or are there ways in which we can actually actualize them in what is happening right now in JNU and other parts of the country? To my mind, there are some practical ways in which one can think about how we can bridge this gap. And those practical ways include, for example, decriminalizing any form of dissent by making any speech offense automatically bailable. The biggest problem and the biggest fear is actually the process. 95% of all sedition cases will not lead to a conviction. They will lead to acquittals. But if the process is the punishment, then you need to ensure that there are some changes in the process that ensure that speech is not expropriated even before it finds its legal arguments in a court. So one way to think of this would be in procedural reform. The other would be to think about this in substantive terms, because if there is something that has happened in the last week, it is a very sad reminder of almost something that had happened during the emergency, where the courts had not responded to the political crisis of the times, where the courts had abdicated their responsibility, in actually responding as guardians of fundamental rights. And maybe it is important to go back into the history, the judicial history of free speech, as a reminder, and with the hope that the courts will not again abdicate their responsibility this time around. Because if you look at the history of freedom of speech and expression in this country, especially in terms of sedition, during the Constituent Assembly debates, sedition was initially included in the restrictions clause of free speech. But it was dropped, and the reason that it was dropped is it found vociferous opposition from all sides, from the left, from the right, because a large number of the people who were part of the anti-colonial struggle had all been charged under Section 124A. So from people like T.T. Krishnamachari to Nehru to K.N. Munshi, all of them opposed the inclusion of sedition in the restrictions clause on speech. So what happened? Why is it that 124A remained then? And what is this problem? If the Constituent Assembly was so clear that sedition should not be included in the Constitution, what was the problem of it kind of continuing? One problem that some scholars like Jayanandita Kasibatla suggest is that the Constituent Assembly debates also happened in the aftermath of the partition, where the entire, partition is the haunting kind of, presence in the Constituent Assembly debates. And she argues that while there are no memorials to the partition in India, unlike, let's say, the Holocaust memorial, the partition is memorialized, unfortunately, as emergency laws in the Constitution, and memorialized in the form of laws like, 124A. And this idea, in a way, of the nervous state that emerged is something that 60 years later we now need very seriously to revisit. What is the problem with sedition? Sedition belongs in Chapter 6 of the Indian Penal Code, which are offenses against the state. You look at what the companions of sedition are in the Indian Penal Code. They are the most serious offenses in the IPC. So you have 121, which is waging war against the state, 122, which is collecting arms for the waging of war against the state. Sedition is the only speech offense in the chapter of offenses against the state. And if you compare this to other speech crimes under the IPC, equally draconian, but if you just compare them, you get a sense of just how serious Section 124A is. The punishment for 153A and 153B, which are the hate speech provisions of the IPC, are 3 years imprisonment. The punishment for sedition is life imprisonment. So you're talking about a scenario in which an extremely draconian law that exists on paper, but has been diluted, severely diluted over the years. So if you just do a quick milestone visiting of what the Supreme Court, for example, has said over the years on the law of sedition, you get a sense of what the standards should be for some speech to be considered seditious. In the very first case in 1957, which was not about 124A, but about public order, the Ramji Lal Modi case, it was clear that this was a very narrow test that the court applied. The question they asked was, is there a tendency to cause public disorder? Now, this is a very, very vague phrase. what does not have a tendency to cause public disorder? Smriti Irani is a walking example of a tendency to cause public disorder, right? So this was a very narrow test that they had applied. Why is this idea of public order crucial? It's crucial because Article 19(1)(a), which is about freedom of speech and expression, is a fundamental right. It cannot be narrowed or taken down except under the conditions laid down in Article 19(2). And as we've established, Article 19(2) does not have the word sedition. The only phrase that is closely proximate to sedition in 19(2) is the phrase public order. So what do you mean by public order became the crucial question for the courts over the years. And in a very important judgment in 1960, in the Ram Manohar Lohia case, they interpreted the word reasonable restrictions in relation to public order to mean that there should be a proximate connection, not a far-fetched connection, between speech and consequences. You had to show a real, actual effect that was going to take place. And the second thing that they established was there had to be a proportionality between the measures that attempted to restrict speech and what it sought to achieve. So how do you then justify, for example, the difference between 3 years imprisonment for 153A and life imprisonment for sedition? This question of the constitutional validity of sedition, a lot of friends earlier said we need to challenge it. We need to challenge the constitutional validity. The constitutional validity was in fact raised in 1962 in the Kedarnath judgment. And in the Kedarnath judgment, the courts managed to save 124A very narrowly. And the reason that they were able to save 124A is because they interpreted 124A to be a very, very narrow domain in which, unless there was an incitement to public disorder and violence, there was no way that 124A could be held to be constitutional. And the courts had to do this because there were already 3 High Court judgments that had ruled 124A to be unconstitutional. The court comes in to save 124A, but it saves it only on the very strict ground that to actually satisfy the criteria of incitement to violence can be the only grounds that you actually have sedition. There have been a number of subsequent judgments, very important ones like Rangarajan, Arup Buryan in 2011, all of which have further clarified what the standards are in actually measuring sedition. And in the most recent judgment, in 2015, in the Shreya Singhal case, which invalidated Section 66A of the Information Technology Act, the courts make a distinction between a discussion, an advocacy, and an incitement. And it's very clear that for a large number of the politicians, for a large number of those who are not even habituated within an ethos of debate and discussion, they cannot make out the distinction between the three. For them, there is no distinction between a discussion and advocacy. Heated debate, a strong disagreement between people is not necessarily an incitement. And this distinction is what we will need to really, really press. This is a judgment that is crucial because it also introduced a new element in overruling a law on the grounds that it violates Article 19(1)(a). And it says, if there is a law that has the consequences of having a chilling effect, of creating, in a way, a condition in which speech cannot be exercised because of an ecology of fear that you will be punished, that you will be beaten up, this chilling effect is a very, very critical ground in which we should think about what it means to revisit a challenge to Section 124A of the IPC. After the Shreya Singhal judgment came out, the noted feminist lawyer Indira Jaisingh tweeted saying, "Congratulations to Shreya Singhal, it's only someone from the under 30 generation that could have obtained this judgment." Apart from this being a very generous compliment from a seasoned legal campaigner, it's also interesting to note because we were reminded in the Rajya Sabha about us being children, right? And this is an instance that we should take to heart. We need to take this to heart because if you look at the history of children and of young people leading the fight on freedom of speech and expression and on dissent, you'll find a glorious history there. Because if Shreya Singhal was a 22-year-old student who could get Section 66A invalidated, there are a whole range of other children in the global history of dissent that we need to learn from. And one such child was a 13-year-old girl who in 1969, when the Vietnam War was happening, had gone to school wearing a black band on her arm. She was asked by her school in Iowa to remove the band, which she refused, as a result of which she was suspended from the school. Much like some of the students here have been suspended from JNU. She was suspended from the school, she went home, figured that there were 13 other children who had done the same thing that day in school, and all of them had been suspended from their schools. She raised a constitutional challenge to their suspension, arguing that this was a violation of their right to dissent. This led to a judgment called Tinker versus Des Moines in 1969, and this was a 13-year-old girl who had brought this case. There are other children who have done similar things. In 1987 in India, in a case called Bijo Emmanuel versus State of Kerala, a case in which a group of Mormon Christians in Kerala had refused to stand up to sing the national anthem, were suspended from their school for being, in violation of the Prevention of Insults to National Honors Act. The Supreme Court in this case held that the right to freedom of speech and expression includes the right to remain silent. And there is no greater act of dissent than remaining silent when the cacophony of ultra-nationalism surrounds you. So let's take her advice to heart, and let's think about how these various children actually teach us a lot about the right to dissent, in contrast to this conservative kind of idea that somehow we don't know what we're doing. These are young students who are there practicing some kind of immature politics, because the real politicians are the ones who are sitting in parliament. Let's not forget that the history of freedom of speech and expression is a history in which these rights have not been granted to you by the courts. Courts have merely affirmed the existence of these rights. These rights were born out of individual struggles, they were born out of social struggles, and they were born out of extremely charged political moments in which questions of nation, nationalism, anti-nationalism were all up for grabs. So let's take back, in a way, the authorship of freedom of speech and expression, because ideals of free speech are not some abstract normative ideals that have been kind of created out of thin air. They are the products of extremely rooted local struggles like the one that is happening today. At the same time, I would warn you about relying in a way too much on the judiciary to be your savior. Because there is also equally a long history of the judiciary playing the role of creating, in a way, or recycling extremely conservative categories. After the 1992 Bombay riots, Joseph Bain D'Souza, the Chief Secretary of Bombay, filed a case against Bal Thackeray under Section 295A for the incitement of hatred. The matter went up to the Bombay High Court, and the proof was, of course, the articles that had been written by Thackeray. The court in this case, in an extremely regressive judgment, made a distinction between ordinary Muslims and Muslims who are traitors, and said that the provision is about incitement of hatred against an entire community, but not against those members of the community who are traitors. There is, therefore, a real danger that in the given current political climate, when the debate around nationalism and anti-nationalism is so polarized, to rely solely on the courts as some kind of saviors of the right to dissent could also run the risk of creating, in a way, a judicial discourse of nationalism and anti-nationalism. So that's something we should keep in mind. Just to say that one shouldn't rely on a juridical model of politics entirely. What I want to kind of, in a way, conclude with are some important questions that we all need to ask ourselves. Because while we're all absolutely clear on where we stand, in relation to this false question of the national, anti-national, and we are not engaging this in relation to the absolute loony right, over the last week, what I have also overheard, and in a number of conversations with ordinary people who you would consider to be extremely reasonable people, is a sense of being upset by what is happening in JNU. Now, of course, at one level, this is about, kind of countering the kind of media falsities that have been perpetuated. But at another level, what if indeed there are a large number of people who feel some kind of hurt, who feel some kind of an injury? How are we to reach out to them, to engage and to have a conversation with them? Where and to what extent do the slogans, the campaigns, the strategies that we currently have, to what extent are they, are they able to actually do this? How are we to think of more creative campaigns, more creative slogans that are actually able to converse with a large number of people? Because the greatest danger, I think, is to actually accept the polarization. Because the politics of sentiment, unfortunately, will always win and trump over the politics of reason. And we are relying entirely right now on the politics of reason. How may we bring a more intelligent politics of sentiment in the way that we lead our campaigns itself? The second thing that I want to think about is, if we began with the idea of the Gadfly as a symbol of dissent and as one of the most powerful metaphors in a way of the right to dissent, what we have in JNU is a swarm of gadflies. And how do we think about the way that the swarm moves in its contagion beyond the walls of JNU? JNU is already a safe space for the exercise of certain forms of speech. But what does it mean to be able to actually support initiatives that are happening in other universities? MS Baroda is facing, in a way, a very, very, very severe crisis posed by the right. In what ways can JNU move out to ensure that this swarm of gadflies that we have actually becomes a contagion across the country? One of the great things that the last 2 weeks has demonstrated, in a way, is that despite how politically bleak it is outside, there is a way in which people inside JNU, some people would say this is delusional, some people would say that this is romantic idealism, but there is a way in which a certain politics of hope that is practiced within JNU, in a way follows for me what one of the great dissenters of the 20th century, Václav Havel, had once said. Václav Havel, while in jail, had once written a very important track in which he said, one has to lead one's life and one's politics as if the conditions that do not allow us were not there, as if it were not impossible, as if we can get whatever we want to demand. And that's the only way in which one can actually have or practice a politics of impossible hope. Because for me, to be hopeful in these difficult times is not just foolishly romantic. It is also subversively and compassionately so. Because it is based on the fact that human history is not just a history of cruelty, but a history of compassion, of courage, and of kindness. Dissenters often have very, very tiny feet, but the little steps that they take are already, in a way, a marvelous victory over the political despair all around. So as you march on the streets of Delhi and on to Parliament in 2 or 3 days, remember that these tiny feet are the ones that are paving in some ways a much, much more radical idea of dissent in this country, which will finally do away with the law of sedition. Thank you.